Hi, I'm Anna Denton-Joseph for Refreshing Law, and I just wanted to update everybody with what's going on with Employment Tribunal fees. You may be aware that a ruling of the highest court in our land, the Supreme Court, came in recently where they ruled that the government's imposition of fees was in effect illegal and quashed those fees, so people can now again issue in the Employment Tribunal without having to pay anything, at least for now. The reasoning of the court is multi-stranded, if you like, but the main argument is a constitutional point that the imposition of fees was preventing access to justice, and that unless we have a system where people can enforce their legal rights, it completely undermines the work of Parliament, indeed even having MPs that might legislate in the first place. So the idea of tribunal users perhaps being equated with service users in some ways and having to pay for that service was undermining that very important legal point. They even went as far back as 1215 and the Magna Carta in their reasoning. One of the other strands in the argument was around the enforcement of EU rights and whether or not it was undermining key principles of European law. And another strand of the argument, particularly picked up by Lady Justice Hale in the judgment, is around sex discrimination and the fact that more women bring a certain type of tribunal claim than men, and that the fees were having a disproportionate impact, if you like, on those types of claims, the smaller claims, if you like, and that in itself was an act of sex discrimination. So lots of reasons why the court found the imposition of fees were unlawful. It did mean that immediately the Employment Tribunal stopped taking fees from people. It also means that potentially the Ministry of Justice has to pay back around £32 million worth of fees that they've taken in so far. Obviously, they will have a record of the people who have paid them that money, but it could be quite burdensome to trawl through and find that information out on each of the individual claims that have happened over a number of years. So it's highly likely that there's going to be some kind of window of opportunity where claimants have the opportunity to perhaps apply to have their fees returned to them. We're waiting to find out what that's going to look like. So if you are a claimant, then you need to be keeping your eye out for what happens in that regard. It also raises the spectre of people who perhaps couldn't afford to bring a claim, trying to bring their claim late now and saying the only reason I didn't bring a claim was the fee. That's now been lifted. Please let me bring my claim late. And we've already started to see people starting to run that argument in the tribunals, and I suspect that the judges may well have quite a lenient view on that given the judgment, and we could therefore see a spike of claims in the immediate future following that decision. Some employers will have made payments where they've lost cases. Typically a claimant would ask for the respondent to, as part of the judgment, pay them back the fees that they had laid out. It's highly unlikely that that's all going to be unravelled. So there is a sense in which some employers will have paid something which now they wouldn't have to. And if the claimant claims their fees back, then they may well get a windfall in respect of that. The other potential issue that comes from the case is that if the principles that the judges were talking about in terms of constitutional law apply to this, then presumably there could be a challenge also to things like the cuts in legal aid and the hike in fees that there have been in the ordinary court system as well. So it may rumble on in other different directions as well. If anyone's got any questions, please don't hesitate to contact me, denton@refreshinglawltd.co.uk, or give me a call 02920 599 993. Cheers, thanks, bye.